this case under the following reasons. 1. The obligation to exchange views under Article 283 of the UNCLOS has already been fulfilled during the video conference meeting that happened on 12 December 2017. Second, under Article 280 of the UNCLOS, parties may choose any peaceful means of their own choice to settle their dispute. Third, under Article 287, Paragraph 1 and Paragraph 4, ITLOS is available as one of the means to be chosen by a state regarding a settlement of disputes. Furthermore, in accordance with Paragraph 4, through the written agreement on 24 April 2020, the parties have chosen ITLOS and therefore must submit only to the ITLOS unless the parties agree otherwise. Fourth, under Article 21 of the Statute of ITLOS, it established ITLOS has jurisdiction over the matters arising from UNCLOS. And last, under Article 32 of the 1996 Bilateral Fishing Agreement, it is stated that disputes arising from the BFA that have failed to be settled by negotiation shall be settled before the ITLOS. It is proven that the 8 meetings in 2018 and 6 meetings in 2019 negotiated by both parties have not settled the case, making ITLOS has jurisdiction over this case. With that being said, the applicant believes that the ITLOS indeed has jurisdiction over this case. Moving on to the first submission, the fishing activities of Azurius in the EEZ of Calypso are illegal and a violation of UNCLOS. The applicant would first like to point out that as both the applicant and the respondent have already implemented the IPOA-IU in their each respective domestic regulation, the definition of IU fishing itself can be taken from the IPOA-IU. And in this case, the conduct by the Azurian vessels which occurred on February, August, September, and November falls within the scope of definition. With that being said, it can be stated that Azurius had violated its obligation, which is embodied in UNCLOS and domestic regulation of the coastal state of the applicant. First and foremost, Azurius had violated the sovereign rights of the applicant under UNCLOS. As stated in Article 56, Paragraph 1A, the coastal state in EEZ has a sovereign right in conserving and managing the natural resources. And in Paragraph 1B, one of the coastal state jurisdiction in the EEZ includes protection and preservation of the marine environment, which is also an obligation according to Article 192 of UNCLOS for all states. The applicant would like to cite from the MV Virginia case, where the tribunal emphasizes that in exercising its sovereign rights in the EEZ, the coastal state is entitled to adopt laws and regulations establishing the terms and conditions for access by foreign fishing vessels to its EEZ. In accordance with this, the applicant had established these rights through the bilateral fishing agreement between the applicant and respondent, and also into its domestic legal instrument, and enforce it in the conduct that had already occurred in September and November. Furthermore, Azurius had failed to fulfill its obligation in Article 58, Paragraph 3 and Article 62, Paragraph 4, which clearly conveyed that all states must comply with the laws and regulations adopted by the coastal state. The applicant would like to cite from MV Saiga case number 2, where the tribunal stated that under the provision of Article 58, Paragraph 3, the rights and obligation of coastal and other states under the convention arise not just from the provisions of the convention, but also from national laws and regulations adopted by the coastal state in accordance with the provisions of this convention. The respondent has failed to, yes, Your Excellency.
If I may, would this tribunal be bound by its previous president?
Yes, of course, Excellency, because it is also one of the primary source of international law, and of course, the tribunal must also consider its past and previous judgment to conclude the matters of this case also.
Thank you. You may proceed.
Thank you, Your Excellency. I will continue. There are several breaches of obligations that can be highlighted. One taken to example is the conduct that occurred on 6 November 2017. The vessels did not have any fishing logbooks, and the species targeted nor the location of the fishing activities were not matching with the actual species fish and the location of these fishing activities. Therefore, in this example, Azurius have breached the obligations stated in Article 6 of the BFA. In the Hoshimaru case, the tribunal is of the view that a violation on the rules of reporting may be sanctioned. The tribunal also states that monitoring of catches, which requires accurate reporting, is one of the most essential means of managing marine living resources, and it is the right of a state to apply and implement such measures. Therefore, through this one example, we can see how Azurius had clearly violated the law and once again failed to do its obligation, which is to pay the fine resulting from the violation. In addition, Azurius refused to pay the fine because it argued that the crew members who conducted fishing activities were simply following fishery stocks, which have moved away from the area of Funiculu because of climate change. Yes, Your Excellency.
You mentioned that there was a breach of not paying the fines. In the clarifications of the Moot problem, it was mentioned that Azurius paid the first fine. What would be the comments on this? Wouldn't you think that they did fulfill the procedure?
Yes, they did fulfill the procedure of sanction applied for the events that occurred in September. However, they did not pay the fine regarding the conduct that happened on November. Therefore, they still breached this obligation to pay the fine resulting from the violation of its vessels. Excellency. May I proceed, Your Excellency?
Please proceed, Counsel.
Thank you, Excellency. Therefore, Azurius acknowledged that there is indeed the intention for this vessel to conduct fishing activities. And this means that these vessels need to fulfill its obligation first under the BFA and Calypso's domestic instrument before they can conduct such fishing activities. Furthermore, the conduct that occurred in November also violates the sovereign rights of the applicant as stated in Article 61, Paragraph 1 of UNCLOS to set the allowable catch in the EEZ. The catch of 12 devil rays is illegal due to its potential extinction and also the size convention. As party to the size convention, the applicant has the right to apply sanction of fine in accordance with Article 8, Paragraph 1A, which enables a state to apply sanction. The applicant strongly believes that this is one of the necessary measures to ensure the preservation of devil rays from possible extinction, which is indeed an act done to apply the precautionary principle as one of the general principles embodied in CITES. Therefore, by condoning the catch of 12 devil rays and refusing to pay the fine, the applicant believes that the respondent had failed to do its obligation as well as party to the size convention as well. Moving on to the second submission, Azurius breached its due diligence obligation. The applicant would first like to cite from ITLOS case number 21, where the tribunal stated that in the case of IU fishing in the EEZ, the obligation that must be ensured and fulfilled by the flag state is an obligation of conduct, which is a due diligence obligation. In addition, as stated in the South China Sea Award, the PCA agreed with the tribunal statement in the advisory opinion that in the context of the duties of a flag state with respect to fishing by its nationals, the obligation stated in Article 58, Paragraph 3 and Article 62, Paragraph 4 extends to a duty to take the necessary measures to ensure that their nationals and vessels flying their flag are not engaged in IU fishing activities. Regarding the measures by the respondent to ensure the compliance of its national as its due diligence, the applicant believes that the respondent had failed to do so. This can be supported by the facts from each of the conduct that had already occurred. For example, on the events that occurred on 30th of September 2017, the Azurian vessels that were seized did not have any fishing logbooks or any adequate fishing authorization on board, which is regulated in Article 6 of the BFA as one of the requirements to be fulfilled by a vessel that wishes to conduct activities in the EEZ. And on November, the Azurian vessel did not have any fishing logbook as well, thus violating Article 6 of the bilateral fishing agreement. The applicant believes that this kind of violation can be prevented if only Azurius had fulfilled its due diligence obligation by ensuring that this authorization or logbook, as one of the requirements stated in the BFA, was already acquired by the Azurian vessels. This clearly shows that Azurius has not taken enough measures to ensure the compliance of its vessel. Even then, on the conduct that happened in February and August, the applicant had decided not to apply the procedure for the violation which is stated in the BFA. The applicant only required the respondent to make its best efforts to control its vessels, such as conducting an investigation, which is also an obligation stated in Article 94, Paragraph 6 of UNCLOS. And furthermore, the applicant believes that this is also a due diligence obligation because it is also one of the means necessary to ensure the compliance of the respondent's vessel in the future. In its advisory opinion, case number 21, The tribunal is of the view that the flag state is under the obligation to inform the reporting state about the action taken. However, the respondent did not inform the applicant about the investigation nor the action that has already been taken. Therefore, this supports the applicant's belief that the respondent indeed had not fulfilled this obligation and seems to have not taken any necessary measures, resulting in several conducts of IU fishing again in the EEZ of applicant. In addition, the respondent had also failed to ensure the compliance of its vessel by failing to enforce its criminal code, which is an obligation stated in Article 94, paragraph 1 and 2 of UNCLOS. Given the light of the conduct that had already occurred, the respondent was supposed to enforce his criminal code to give a deterrent effect as a way to ensure the compliance of its national. This is in accordance with the tribunal statement in the advisory opinion case number 21, stated in paragraph 137 and paragraph 138. However, the respondent did not enforce it, thus making the conduct of IU fishing in the applicant's EEZ to go on again several times. With the arguments aforementioned before, the applicant asked the tribunal to declare that first, the fishing activities of Azurius in the EEZ of Calypso are illegal and a violation of UNCLOS. And second, Azurius breached its due diligence obligation under UNCLOS. With that being said, that concludes my first two submissions regarding the merits of the case. The pleading will continue with my co-agent, Mr. Brian Edwardus. Thank you, Your Excellency.
Madam President, Your Excellencies, members of the Tribunal, good afternoon. May it please the Court. My name is Brian as the co-agent of the applicant, Republic of Calypso. I will be speaking for the next 18 minutes, addressing the last two submissions, which are first, the conduct of illegal fishing activities in the EEZ of Calypso cannot be justified by a state of necessity and/or climate change. Second, Azurius is responsible for the food security issues its inhabitants are facing. It indeed failed to plan well ahead on the basis of best scientific evidence available, the management, preservation, and restoration of its marine environment and resources. Your Excellency, the applicant would like to establish a grounds concerning the admission of guilt by the respondent. It is needed to be established in the court that activities on September 2017 and November 2017 are similar and alike. On September, there was a malnutrition issue known from the case. Next, in November 2017, there was a food shortage. Both of the defenses are used by the respondent as grounds to justify their actions. This claims is based on the fish stock migration warned by the Pacific Ocean Advisory Body and Curious 16 impacted that the UNGA declared. These two reasons are gradually happened since 2016 until the time frame that this case occurred. However, what the applicant would like to point out is that the respondent admit the guilt on September by paying the fine imposed by the applicant. But later on, the respondent used the defense of state of necessity for the November 2017 event, which apparently have the similar conditions. This is very contradictory with one another. The conduct is unacceptable, Your Excellency, as the applicant would like to introduce the doctrine of estoppel. The principle of estoppel is a general principle of law, which is a source of international law under the Articles of the 38 ICJ Statute, thus this may be applicable. In the MV North Star case, Panama versus Italy, ITLOS preliminary objections judgment, the tribunal stated a situation of estoppel exists when a state by its conduct has created the appearance of a particular situation and another state relying on such conduct in good faith has acted or abstained from an action to its detriment. The effect of the notion of estoppel is that a state is precluded by its conduct from asserting that it did not agree to or recognize a certain situation. The elements of estoppel, as the MV North Star Tribunal declared in paragraph 307 are first, representation by conduct, word, or silence, which Azurius fulfilled by word and conduct, in this case, replying to the applicant on 20 November 2017 and paying the fine of 12,006 euros. Second, evidence of representation. In this case, the evidence of the representation are the fact that the respondent paid for the fine. In conclusion, the respondent shall not plea for state of necessity because they admit the guilt for the September 2017 as they did not have any knowledge and it was under the defense of malnutrition. This has the same elements of on the state of necessity arguments they bring for the November 2017, which is shortage of food, as well that caused by the same Curious 16. Thus, the court shall stop the respondent claim on this. But even if the respondents still bring the arguments of state of necessity, the applicant will respond with our third submission. The applicant would like to point out that the conduct of illegal fishing activities in the EEZ of Calypso as there was not justified by a state of necessity and or climate change. This submission will be divided into two parts. First, I'm going to elucidate why this couldn't be justified as a state of necessity, then relating the illegal fishing activity to climate change. Based on Article 25 of the International Law Commission's articles on state responsibility, in order to justify an illegal fishing activities by a state of necessity, it needs to be the only possible way for the state to safeguard an essential interest against grave and imminent peril, does not seriously impair an essential interest of other states, and the state does not contribute to the necessity condition. Necessity as a circumstance precluding wrongfulness must fulfill a very strict requirements to be considered as a valid excuse. Your Excellency.
Counsel,
Yes, Your
sorry,
Excellency.
if I may, what is the weight of the ILC articles as a source of international law?
Okay, thank you, Your Excellency. I'm going to answer your question. So this can be used because there is a principles in international law which was called the customary international law. So this could be a source of law to be used in discussing this case. So I'm going to continue my pleading, Your Excellency.
Thank you.
Okay, one thing to be considered is that this is categorized as the cumulative requirements, meaning that the respondent must prove all the requirements stated on Articles 25 of the ILC. If they fail to do so, then the ITLOS should dismiss their entire claim on state of necessity. Azure's Illegal Fishing Act couldn't be justified by a state of necessity based on the following facts and arguments. First, the conditions in Azureus does not indicate a grave and imminent peril. A state can only invoke a state of necessity if its essential interest is threatened by a grave and imminent danger. The ILC highlighted that the peril must be extremely serious, a threat at the actual time. The danger has to be objectively established and not merely apprehended as possible. According to the Gapsi-Kofonagi-Maros case, the danger must constitute an extreme and actual threat or peril with a very high standard of proof to establish necessity. Both parties, Hungary and Slovakia, have placed on record an impressive amount of scientific material aimed at reinforcing their respective arguments, but the grave and imminent peril wasn't met. In this case, Azureus' claim has not met the high standard of proof stated in the International Court of Justice either. The documentary released on the website of BBC and a statement by a former guide on the northern beaches are not enough to prove the existence of the serious peril. The occurrence of malnutrition issues suffered in the north of the island is also not a strong argument to categorize this as grave and imminent peril, because it is not impacting the whole Azureus. By the warning in 2012, respondents should have started to consider the possibility that fish migration due to climate change would occur in 2015. From the facts above, we can draw a conclusion that the respondent doesn't prepare themselves for predictable conditions that would possibly occur in the future, which proves that this is not an imminent danger. Therefore, the conditions in Azureus does not indicate a grave and imminent peril, yet they still stated that this could be justified by a state of necessity. Second, it was not the only way to face the food crisis. Articles 25 of the ILC stated that the measures taken must be the only way available to safeguard that interest. The plea is excluded if there are other lawful means available, even if they may be more costly or less convenient. The illegal fishing actions done by Azureus could be justified if it is the only means in facing the food crisis issue. Azureus should be able to use other methods in dealing the food crisis, such as what Fuji as a small islands developing states did in facing the pandemic by introducing a home gardening initiative. Other possible options were not tried by Azurius before committing the act of illegal fishing. It is also explained in the commentary of Article 25.15 that the only way is not limited to unilateral actions and solutions, but includes cooperation with other states or international organizations. According to the Staller case, Azurius had not done any sort of cooperation with other states or international organizations, including a cooperation with Calypso. Excellent relationship of both states since their respective ratification of UNCLOS shouldn't be a big problem to ask Calypso for help in dealing with the food crisis.
Council?
Yes, Your Excellency.
Don't you think from the amount of catch taken on November, on the amount, it was all in kilograms, and the devil rays were only 12. Would you think that that amount can be interpreted that they were fishing under the basis of necessity?
Thank you, Your Excellency. The answer will be explained further in my next argument, but to explain it shortly, the endangered species still would impact the balance of the ecosystem of Calypso in the long term. So the impact is lasting for a long period of time. Maybe I'm going to explain further in my next argument, Your Excellencies. My third argument is the illegal fishing activity have impaired an essential interest of Calypso. A wrongful act to protect a state's essential interest, even under a state of necessity, must never damage the essential interest of other states and or international community. As defined in Gapsikovo Nagimaros, that ecological balance is an essential interest for all states, and the illegal fishing activities done by Azurius has violated this interest. The fishing of 12 devil rays in 6th November 2017, which is so very appreciated in the traditional culinary culture of Azurius as an endangered species stated in Annex 1 of the TAC. On another occasion, Azurius also stole 120 kilograms of Spanish mackerels, which was also listed. Both of these cases would adversely impact the respondent's fishery stocks in the long term, because the essential interest is talking about the stability of its marine environment. Another supporting fact that this have impaired an essential interest of Calypso is that this was located in the Gold Seahorse area of the EEZ of Calypso. The Gold Seahorse itself is located 54 nautical miles from the outer limits of Honikulu of Azurius, which shows a certain intention. The illegal fishing activities cannot be justified by a state of necessity because to be justified, they don't need to go that far to the Gold Seahorse. In conclusion, this illegal fishing have impaired an essential interest for Calypso. My fourth argument relating this to the state of necessity is Azurius contributed to the food security issue. Subparagraph 2b of Article 25 ILC established that necessity cannot be invoked if the responsible state has contributed to the situation of necessity. For this plea of necessity to be precluded, the contribution must be sufficiently substantial and not merely incidental or peripheral. The failure of Azurius on ensuring the proper conservation measures to protect their fishery stocks caused the fishes to move away from Honikulu. Azurius itself contributed to the food security issue they faced. Therefore, these illegal fishing activities couldn't be justified by a state of necessity. Moreover, this is also unjustified using climate change as a reason. This illegal fishing act couldn't be justified by climate change because Azurius couldn't provide a strong scientific evidence. Besides, fishery stocks such as red snappers and mahi-mahi were categorized as a highly migratory species as listed in Annex 1 and isn't directly impacted by climate change, so it couldn't be a justification for this case.
Okay, Council, sorry, I'm just going to interrupt you just now. In paragraph 8 of the problem you were given, the Pacific Ocean Advisory Body, as well as independent experts, and then supporting articles published in Nature as well, so an internationally renowned peer-reviewed scientific journal, warns about the potential relocation of red snapper and mahi-mahi as well. So there was a strong don't you agree there was a strong scientific basis for the fact that these species might relocate due to climate change?
Okay, thank you, Your Excellency, for the question. I'm going to answer your question. So yes, there is a warning, but it is not included as the best scientific evidence under the UNCLOS threshold. As the Gapsi-Kovo-Nagimaros case, the weight of the proof is high, so this couldn't be justified as a scientific evidence to prove that this could be done by climate change reason. May I continue, Your Excellency?
Yeah, please continue.
Okay. So therefore, all the arguments above supports the applicant belief that the respondent's action couldn't be justified by a state of necessity and or climate change. Turning now to our last submission. The food insecurity issue faced was their responsibility because of these several reasons. First, failure on cooperating before executing an illegal fishing act as a failure of management. Article 63, paragraph 1 of UNCLOS stated the obligations for state with the same fish stock in their EEZ to conserve and manage the stocks, either directly or through appropriate sub-regional or regional organizations. Azurius did none of these actions in order to face the food insecurity issue and decided to immediately done an illegal fishing activity in the EEZ of Calypso, with the defense as the only means. The failure of Azurius on managing their marine environment and resources was proved by not ratifying the FAO agreement on port state measures and are not a member of any regional fisheries management organization. Azurius didn't prove its commitment on combating illegal fishing by not ratifying the PSNA. Besides, by not joining any regional fisheries management organizations, it worsens the condition and shows that Azurius had no plan to cooperate with sub-regional or regional organizations as mentioned in the article above.
Counsel, what did you think the fact that the respondent is a party to the Lobby Convention is enough to establish the threshold that they abide to the concept of the obligation to cooperate?
Okay, thank you, Your Excellency.
In the bilateral agreement, you have mechanisms where you meet regularly and talk about these things. Wouldn't that constitute their commitment to preserve the marine environment together as sovereign states?
Okay, thank you, Your Excellency. They need to prove more effort by ratifying the PSMA and also joining organizations because they should done more because the 20 years of exploitation that they done in the past. I'm going to continue my pleading, Your Excellency. My second argument is Azurius failed on protecting its marine environment based on scientific evidence. Articles 192 of UNCLOS describes the obligation of states to protect and preserve the marine environment. These obligations must be done by taking into account the best scientific evidence available to it based on Article 61, paragraph 2 of UNCLOS. Azurius was in fact warned by the Pacific Ocean Advisory Body that its fishery stocks would have relocated by 2015. However, Azurius did not take the warning from the POFAB and independent experts of the possible fishery stocks migration in 2015 as a consideration. This can be seen from their domestic policies as stated in Articles 168.1 and 168.2 Marine Policies and EEZ Management Act, which still allowed artisanal and even industrial fisheries. Both of these are still allowed in the Act passed in 2014, which was after the warning as mentioned above. Therefore, it can be concluded that Azurius has failed to consider the best scientific evidence available to it and take adaptive measures. Third, Azurius failed on planning ahead. 20 years of harmful fishing practices lead to the overexploitation and collapse of many fishery stocks and marine habitats in general. Although the president of Azurius supported new long-term marine restoration policies, the impact of all the actions that have lasted in the past remains. Other evidence supporting applicants' argument is the fact that Azurius had just made their marine policies and EEZ management regulation in 2014, while BFA itself has been around since 2002. Therefore, we can conclude that the respondent Azurius in this case is completely responsible for the food security issues they faced because of their failure in planning the protection and preservation of their marine habitats and resources. Madam President, Your Excellencies, members of the Tribunal, the respondent respectfully requests the Tribunal to adjudge and declare that first, the fishing activities in the EEZ of Azurius in the EEZ of Calypso are illegal and a violation of UNCLOS. Second, Azurius breached its due diligence obligation under UNCLOS. Third, the conduct of illegal fishing activities in the EEZ of Calypso cannot be justified by a state of necessity and or climate change. Lastly, Azorius is responsible for the food security issues its inhabitants are facing. It indeed failed to plan well ahead on the basis of best scientific evidence available, the management, preservation, and restoration of its marine environment and resources. With the foregoing arguments, the applicant concludes our submission relating to the merits of this tribunal. Thank you. May it please the court.
Thank you very much, representative from the state of Calypso. That was with 32 minutes there, so you have 8 minutes for your Sir rebuttal. I now give the floor to the respondent. You have 40 minutes, please. You have the floor.
Honorable President, excellent members, the respondent would like to divide its time in the following manner: 18 minutes for the agent, 19 minutes for the co-agent, and 3 minutes for sub-rebuttal. Well, Honorable President, excellent members of this tribunal, distinguished representatives of the state of Calypso, good afternoon. My name is Eloisa Alves, and it's an honor for me to appear before this tribunal on behalf of Azorius with my co-agent, Ms. Rafaela Azevedo. With the permission of this tribunal, I will spend the next minutes, first, clarifying the events that gave rise to the dispute. Second, requesting the inadmissibility of the fourth submission of Calypso. Third, demonstrating that Azorius did fulfill its flag state's duties. And fourth, proving that the second fine issued by Calypso is abusive. These disputes concern alleged illegal fishing activities that supposedly occurred throughout 2017 in the Stellar Sea. However, it is interesting, Your Honors, that the representatives of Calypso did not mention that first, under Bigai's new agreement, all data is first received only by Calypso, meaning that only Calypso had direct access to that information. Second, it is widely known that the pandemic caused by Curious 16 inflicted Azorius' economic and social system, and its population is suffering serious malnutrition issues. Finally, Calypso does not have any conclusive proofs of the incidents of February, August, and September, as the Coast Guard of the state of Calypso was not working properly, and there were no inspections in the Azorian vessels, in accordance with Article 12 of the 1996 Bilateral Fishing Agreement. After this brief elucidation over the real facts, I pass on to a question over admissibility. This tribunal jurisprudence in the cases NV Saga and NV Virginia already recognized that the parties have the right to raise objections over admissibility. Well, Calypso requires that this tribunal declare that Azorius is the one responsible for the food security issues its inhabitants are facing, and that the state failed to plan the management, the preservation, and the restoration of its marine environment and its resources. However, the jurisdiction of the International Tribunal for the Law of the Sea lays over disputes concerning the interpretation and the application of the United Conventions for the Law of the Sea and the other treaties that are related to the purposes of this convention. This is clearly stated in Article 288 of the Convention and Article 21 of the Statute of ITLOS. Therefore, Your Honors, the submission of Calypso requesting a declaration of this tribunal of responsibility of Azorius over food security issues is inadmissible once these matters are out of the scope of the Convention and of international law of the sea. I will now continue the defense, and I will demonstrate that Azorius did fulfill its duties as a flag state. First of all, Azorius respected Article 94 of the Convention and has been committed with all the possible efforts to prevent the alleged violations, and for that reason cannot be liable for not being able to avoid some vessels from engaging in supposed IUU fishing activities. This tribunal already defined that the flag states are not obligated to achieve this result, According to ITLOS, the Article 58.3, 62.4, and 192 of UNCLOS impose obligations on states to have due regard over their vessels. This tribunal already stated, and I quote, "The sponsoring state's obligations to ensure is not an obligation to achieve. This is an obligation of conduct and not of result, and as an obligation of due diligence." The sponsoring state, Azorius, has taken all the necessary measures to comply with its duties and to ensure that vessels flying its flag do not conduct any illegal fishing activities. Here we can give you some of examples. Yes, Your Honor?
Also, yes. So is there no duty to sanction the vessels that have been fishing in the EEZ of Calypso?
Sorry, Your Honor, could you please rephrase the question?
Should the Azorius state not have reacted in some way to the vessels that had already fished in the EEZ of Calypso? In some form of sanction or response to those actions?
Yes, Your Honor, I understand your question. And we will see briefly how did Azorius fulfill its duties as to respond to Calypso and respond to the vessels that supposed committed these violations. So, giving some examples of how Azorius ensure these obligations. First, Azorius issued correct fishing authorizations that were in full compliance with the 1996 bilateral fishing agreements. Second, Azorius created in its domestic legislation laws to control their vessels and to punish violations committed by them, as for instance, Article 78, paragraph 4 of the Azorian Criminal Code. Going beyond that, Azorius created marine protected areas. The state also promoted communication campaigns domestically and abroad on the policies adopted to fight IUU fishing. And the state has been committed with the cooperation principle as expressed in Article 64, 117, 118, and 197, and the preamble of the convention. Therefore, Azorius surely comply with its most important duty, that is due diligence. Now, not only Azorius is being wrongfully accused of committing violations, but it has also been curtailed of one of its most important rights, the freedom of navigation. Calypso has breached the convention that recognizes this important principle of the international law of the sea. This tribunal cannot allow the vain violation of such an important principle.
Counsel.
Yes.
As a flag state, wouldn't you think that you had the responsibility to ensure that your vessels are sailing under marine zones that are allowed, in a sense that both countries have their special protected areas? And when it is already defined and published, wouldn't you think that there is an obligation to tell your vessels or warn them in some way that there are certain bodies of water that are under protected status?
Your Honor, the correct fishing authorization is issued by Azorius. It's a way that the state had to try to prevent that their vessels were fishing in the correct localizations, as they were always communicating, and all the fishing vessels were obligated to have the VMS, that's the system that sends the information of the location. Well, all the possible efforts that Azorius, that is a small island developing state, could promote to prevent their vessels under their flag were not violating the rules of IUU fishing.
Thank you.
Thank you. Well, finally, the tribunal already established a rule in the NV-sided case, that is, Given the choice between a legal classification that implies a violation of international law and one that avoids such implication, it must opt for the latter. Well, Calypso's requests the classification of the activities as IUU fishing. However, considering that it does not own any conclusive proof that Azorean vessels were fishing in its protected areas, implying a violation, and on the other hand, Azurius took all necessary and appropriate measures to comply with its duties, avoiding such implication, the tribunal must opt for the latter in conformity with international law and this tribunal jurisprudence. Finally, Your Honors, Azurius requests this tribunal to declare that the Azurian state is not liable for the alleged violations, and it has taken all necessary measures to comply with its duties and to ensure that vessels flying its flag do not conduct any illegal fishing activities. Now, I am going to demonstrate that the second fine issued by Calypso of more than 150,000 euros is abusive and was quantified on patent bad faith. First of all, it is important to clarify that the first penalty was willingly paid by Azurius in order to maintain the good relationship between the two countries, as there is no accordance concerning the veracity of the facts alleged by Calypso. Therefore, the estoppel principle does not apply here as argued by the representatives of Calypso. While Azurius Acts demonstrates again the commitment with the principle of cooperation, the discrepancy between the values of the two fines shows the bad faith of Calypso as it aims to exploit Azurius, a small island developing state already dealing with so many hardships caused by external factors. It is important to point out that according to the Pacta Sunt Servanda principle, international obligations must be carried out in good faith as stated in Article 26 of the Vienna Convention for the Law of Treaties, which was considered a reflection of customary international law by this tribunal in the advisory opinion, case number 17. Therefore, the absence of reasonable parameters for an increase of 1,156%. Yes, Your Honors, it was an increase of 1,156% on the value of the penalty by Calypso constitutes a violation of good faith. Furthermore, this tribunal already analyzed the concept of reasonability concerning monetary values on many cases of prompt release. It started with the MV Saiga case that stated the necessity of reasonability for the quantification of any financial security concerning the international law of the sea. In this regard, although this unjust penalty is not per se a financial security, there are clear precedents on this tribunal regarding the general concept of reasonability. Certainly, these interpretations must be analogically applied to the quantification of the fine imposed by Calypso to ensure the principle of good faith as stated in Article 300 of the Convention. Finally, even if Article 12 of the 1996 bilateral fishing agreement does not impose a clear parameter to quantify the fine, it does not grant Calypso a discretionary power to ignore the guidelines of this tribunal and of international law. Therefore, the Azurian government requests this tribunal to declare the unreasonability of the fine by declaring it illegal. And if for any circumstance this honorable tribunal does not decide for the illegality of the fine, Azurius requests it toning it down to a reasonable value. Honorable President, excellent members of this tribunal, I thank you for your kind attention. And now I would like to suggest calling to the stand the co-agent, Ms. Rafaela Azevedo, who will continue our oral statement. Thank you very much.
Thank you. Yes, please continue.
Honorable President, excellent judges of the tribunal, distinguished representatives of the state of Calypso, good afternoon. My name is Rafaela Azevedo, and for the next minutes, I will continue with the defense of the state of Azurius. Throughout my speech, I will demonstrate that, first, the Azurian vessels did not practice illegal fishing activities or cause any damage to the natural environment. And second, Azorius did not violate the United Nations Convention on the Law of the Sea or any other international agreements once the fishing activities conducted by its vessels replied to a grave and imminent danger faced by its inhabitants, exacerbated by climate change. I'm going to start this presentation highlighting that Calypso does not have any proofs of illegal fishing activities conducted by the Azorian fishing vessels in its no-take zones, but only satellite images captured by the European Union service Big Eyes on You testifying the possible location of the vessels. The vessels were arrested outside of the zone, in the area where they were supposed to be fishing according to their license. It is important to stress that despite being designed by the European Union, the Big Eyes on You project is directly linked to Calypso. The reliability of its data cannot be confirmed by a third party, as they are sent directly to Calypso. Also, the paragraph 322 of the South China Sea Arbitration, which is recognized by Article 38 of the Statute of the ICJ as jurisprudence, the arbitral tribunal understood that the general point that the satellite imagery may be a very useful tool, but cannot accept a high degree of accuracy or certainty of such imagery. According to the International Plan of Action to Prevent, Deter, and Eliminate Illegal, Unregulated, and Unreported Fishing, that was mentioned by the applicant, and as a non-legally binding document is considered as soft law, was implemented by both parties within their domestic legislation. The illegal fishing activities refer to activities conducted by national or foreign vessels in waters under the jurisdiction of a state without the permission of that state. In both first and second, yes, Your Honor.
Regarding the Big Eyes on You agreement, it was also negotiated by your country. Why are you not accepting the satellite imagery?
Yes, Your Honor. Actually, Azorius is not questioning the Big Eyes on You project in itself as a tool for prevent IUU fishing, but we are trying to make a point here that the satellite imagery is not a very useful tool in itself without a concrete evidence that the location of the vessels. It is a practice on states that with the satellite images may be used in compliance also with an inspection or other concrete evidence that can testify that the vessels were located in the actual no-take zones. So in this sense, where the fishing activities carried out by the Azorian vessels were located around only 2 nautical miles away in the first and second events. In this sense, considering the uncertainty of the satellite images and the lack of any other inspection or other concrete evidence provided by Calypso that the vessels were actually in its no-take zone, it is not impossible that the locations of the vessels informed by the Big Eyes on You service wasn't accurate. And in this sense, no fishing activity would have occurred without the permission of Calypso and cannot be classified as illegal. Did I answer your question, Your Honor?
Yes, you did. Thank you.
Okay, so in the first and second events, differently from the report given by the Big Eyes on You service, the notification of the vessels received by Azorius informed that the boats were located around only 2 nautical miles away from the no-take zones of Calypso in locations matching the fishing authorizations in full compliance with the 1996 bilateral fishing agreement. In the third event of September 2017, 2 other Azorian vessels were targeted and arrested by Calypso. Although the ships had a license, the crew committed a mistake in their positioning and the species being caught. The species caught were not endangered, and the amounts of fish were well inside the total allowable catch limits of the 1996 bilateral fishing agreement. The representatives of Calypso claims that these actions were illegal. This accusation was made without any previous investigation or judicial process. Considering that the crew of the vessels was composed by members of a small coastal community facing important malnutrition issues, it is important to recognize the lack of technical knowledge of the fishermen that led them to enter the wrong area by mistake. The United Nations Special Report on the Right to Food, also a soft law document, highlighted the importance to distinguish IUU fishing, industrial IUU fishing, from subsistence fishing, stating that analogizing these catches to illegal fishing underestimates their role in contributing to food security and does not encourage the fishers concerned to shift to more responsible practice. In this sense, Calypso cannot assume that every failure in complying with every provision of the agreement, especially when practiced by subsistence fishermen, is an illegal fishing activity. This tribunal has already determined in the MV Virginia G case in its paragraph 266 and 270, brought up by the applicant, that coastal states cannot act in an arbitrary way or out of proportionality, stating that in applying enforcement measures, due regard has to be paid to the particular circumstances of the case and the gravity of the violation. These incidents represent a breach of this tribunal jurisprudence. Calypso apprehended a vessel that was not causing any relevant damage based on a minor mistake over the content of the license, especially considering that the fishing content was covered by the total allowable catch limits. The Article 73.1 of UNCLOS established that the coastal state may, in the exercise of its sovereign rights, take measures as may be necessary to ensure compliance with the laws and regulations adopted by it in conformity with the Convention. As it was stated by Judge Ad hoc Sevelo Correa in his dissenting opinion in the Virginia G case, necessity is one of the three sub-principles of the legal concept of proportionality, consisting of the duty to use the least onerous means to reach a legitimate end. Necessity implies that unnecessary sacrifices of rights are not permitted. In the present case, it was not necessary to apprehend the vessel, seize its fishing hold, and send a fine to Azurius over a small issue with the license, when a notification would have been enough. From these incidents, it becomes clear that the fishing activities conducted by the Azurian fishing vessels weren't illegal, and the authorities of Calypso exaggerated minor situations by escalating them and acting out of proportionality. Now, initiating the second part of my statement, I'm going to demonstrate that the fishing activities carried out by the Azurian vessels replied to a grave and imminent danger faced by its inhabitants, exacerbated by climate change. The fishing activities of the fourth incident of November 2017 can be framed as a subsistence activity carried out in a context of imminent peril that fits the state of necessity and precludes its wrongfulness, according to Article 25 of the International Laws Commission's draft articles on state responsibility. This tribunal already recognized the state of necessity on the MV Saiga case. The International Court of Justice, established in the Gabtkovna-Guimarães project case, brought also by the applicant, the conditions to configure the state of necessity, perfectly applying to the present case because, first, securing the right to food to its population is an essential interest of Azurius. Second, with the paralysis of the international trade, Azurius was not anymore able to import food, and its inhabitants were forced to subsistence farming and fishing, which configures a scenario of grave and imminent danger. Third, the fishing activities beyond the authorized area were the only means to secure the right to food of the population, considering the paralysis of the international trade and the relocation of fish stocks to outside of the easy of Azurius caused by climate change. And fourth, the fishing activities of small Azurian vessels did not affect any essential interest of Calypso once the amount of fish caught was insignificant. And for last, Azurius did not have any control over the economic crisis caused by the pandemic or over the climate change that affected the route of the fish species in the region. For these reasons, it is clear that Azurius fits the hypothesis of state of necessity, what precludes its wrongfulness over any acts considered as internationally wrongful conducted by the vessels flying its flag.
Counsel,
In addressing the claim, Yes, Your Honor.
Could you please describe the elements of an internationally wrongful act?
Yes, Your Honor. As described by the International Laws Commission's draft articles on state responsibility, on Article 2, the internationally wrongful acts are the acts conducted by states that offers a violation in the rights and the jurisdiction of another state, being considered as internationally wrongful. Did I answer your question?
Yes, please proceed.
Thank you. Addressing now the claim of the applicant, Calypso also did not ratify the FAO Agreement on Port State Measures, the PSMA, and is not a member of any regional fisheries management organizations. So Azorius is not alone in this non-ratification of this document. Also, Azorius was one of the nations most impacted on what the Food and Agriculture Organization of the United Nations declared as the World Hunger Crisis, facing specific social, economic, and environmental vulnerabilities. Considering this context, I'd like to highlight the denial of Calypso to comply with its duty to cooperate. The international community, including Calypso, was fully aware of the effects of climate change on the availability of food to Azorian nationals since 2012. This scenario worsened with the Curio-16 virus outbreak and the consequent economic crisis. However, apparently ignoring the recommendation of the United Nations General Assembly of 15 June 2017-16, Calypso did not contribute with any collective measures for the prevention of threats to the respect of human rights, but on the contrary, seized the fish holds and arrested Azorius subsistence fishers from small coastal community that nowadays faces severe malnutrition issues. Many international treaties establish the duty to cooperate, including Article 5 of the United Nations Fish Stocks Agreement, ratified by both parties, especially taking into account the interest of artisanal and subsistence fishers. Also, cooperation is one of UNCLOS principles, fixed in its preamble and many articles along the convention. Azorius did not fail on its duty to cooperate at any moment, but Calypso did not reciprocate, arresting the vessels of small Azorian subsistence fishers without considering the state of necessity that these people were facing with the climate change effects in their access to food. Addressing now the climate change issue, the fourth instance was clearly a case of subsistence fishing activities with no economic dimension. The three small fishing vessels were carrying a total amount of 212 kilograms of fish. For comparative reasons, we can consider that in the Hoshimaru case, this tribunal recognized the fishing activities conducted by the vessels as commercial activities, as the amount of fish caught was of 275 tons of fish. The amount of fish caught in the fourth instance would not be enough for commercialization, especially considering the malnutrition context in the community of these fishermen. As well as the fishing activities of the fourth instance, the third instance might also be recognized by this tribunal as subsistence fishing. Regardless of the quantity of the seas fished, that in the third instance, even with a full fishing hold, was of a total of only 120 kilograms of fish, the aim of the fishing was to provide food for the Azorian inhabitants in times of a global food crisis that especially impacted the country. In this sense, none of the fishing activities conducted by the Azorian vessels replied to within the easy of Calypso might be considered as illegal, but as subsistence activities conducted to provide food for the Azorian population in times of crisis. For all the reasons explained, this case fits the hypothesis of preclusion of wrongfulness for state of necessity, and therefore, Azorius must not be held liable for the violation of any international law provisions. For all the foregoing, Your Honors, they violate any articles of UNCLOS or other internal provisions alleged by the state of Calypso. Finally, Azirius reiterates its concern and diligence to face the new challenges brought by this time of crisis.
Thank you very much, representative from Azirius. That gives you just about 10 minutes for your rebuttal. Now, along with the rules of procedure, I will give the floor to Calypso, the applicant. You have 8 minutes for your rebuttal. You have the floor.
Thank you, Your Excellency, members of the tribunal. The applicant would like to submit 5 rebuttals. On the whole submission, there is no response from the respondent concerning the doctrine of estoppel, as the applicant already argued that the plea of necessity may not be used as the respondent were being inconsistent with their conduct and words. Meanwhile, the applicant already established the doctrine of estoppel through the MP North Star case, Panama versus Italy, as well as the elements that are fulfilled in the Stellar case. The respondent also stated that the fine issued by Calypso is abusive. The applicant would like to state that no grounds of abusive that Calypso established. It is very subjective without legal standing. The applicant did not use, the respondent did not use any supporting legal precedent nor source of international law in declaring that the fine is excessive. Next, referring to the Calypso domestic instruments, which is the criminal code, it is stated under Article 92, paragraph 3, that the fine of 12,000 euros is minimum, and it is subjected to the gravity of the crime and the fish code. The Code of Devil Rays highly impaired the essential interest of Calypso due to its highly endangered status. The preservation and conservation of the marine living resources cannot use the approach of species by species. The approach that must be used must be an ecosystemic approach, where an extinction of a species, in this case the devil rays, can disrupt the ecological balance of the applicant's marine environment as well. Therefore, the applicant believes that this amount of fine is a way to give a deterrent effect for the Azurian vessels to act for the best interest of preservation of the species. Second, on the point of flag state duties and due diligence concept, the respondent has 2 responses. First, the respondent stated that it has taken all necessary measures. However, they did not further elaborate more about this. Article 94, paragraph 1 and 2 of the Convention provides that the flag state is under an obligation to exercise effectively its jurisdiction and control in administrative matters over fishing vessels flying its flag by ensuring in particular that such vessels are properly marked. However, the respondent, as mentioned before, did not enforce its jurisdiction, thus making the IU fishing to go on again several times. Azurius has still failed to notify the time of entry in one of the cases, as well as not providing logbooks in both of the September and November 2017. 3. On the third point regarding the big eyes on you. First, on the event that happened in February and August 2017, the applicant argued that both Azurius and Calypso have already agreed on 10 of June 2005 to use the big eyes on you as one of the efforts of cooperation towards IU fishing. Thus, it is not understandable for the respondent to not accept the big eyes on you as a preliminary evidence. In addition, this shows once again that the respondent has once again violated the estoppel principle, where they already agreed regarding the use of big eyes on you to eradicate IUU fishing. However, now when it is unfavorable to them, they question the admissibility of the big eyes on you. Next, but even if the respondent would still like to argue that the big eyes on you is insufficient, the respondent did not even provide any legal case interpretation on what would be sufficient evidence. Thus, the definition of insufficient evidence is very subjective. On the fourth point, regarding state of necessity, the applicant has 3 responses. First, as mentioned by my co-agent, that state of necessity must apply all the elements in Article 25 of RCWA cumulatively. On the other hand, the respondent did not provide any legal case or precedent concerning the application of state of necessity. Meanwhile, the applicant already introduced the Gapchikovo-Nagimaros case and elaborates it. Second, the respondent argued that the Code of 12 Devil Rays did not impair essential interests of Calypso. Meanwhile, both the applicant and respondent have ratified the CITES Convention, which highly prohibits the Code of Devil Ray. Devil Ray, in itself, is a highly endangered species which will harm the ecological balance of Calypso. Thus, it impaired the interest of Calypso. Third, the respondent stated that there is no other means. However, the applicant already mentioned that there are other alternatives for seeds, such as what Fuji did. Moreover, the curious 16 happened on 2016, and then there were a gap of 1 year to conduct other means, but the respondent chose not to. Last, regarding the Hoshimaru case, the applicant would also like to say again that in the Hoshimaru case as well, the tribunal is of the view that a violation of the rules on reporting may be sanctioned. The tribunal also states that monitoring of catches, which requires accurate reporting, is one of the most essential means of managing marine reefing resources. With respect to what has been stated, the applicant believes that the respective ITLOS tribunal shall decline the respondent's submissions due to the lack of source of international law, legal interpretation, and case precedent. Thank you, Your Excellency and members of the tribunal.
Thank you very much. I now give the floor to the respondent for your rebuttal. You have 10 minutes if my watch is right.
Okay, so Honorable Tribunal, about the claim of the applicant about the lack of precedents in the state of necessity. Well, we brought up to this tribunal the precedent of the MV Saiga case in the paragraph 129, where this tribunal recognized the state of necessity as a hypothesis of preclusion of wrongfulness. So this hypothesis is also recognized by this tribunal, and considering the jurisprudence of the ICJ also brought up in our statement about the Gavtikovo-Nagmarus project case in its paragraph 51, yes, Azurius does fits the hypothesis of state of necessity once all the conditions established by the ICJ in the Gavtikovo-Nagmarus project case are cumulatively fits the case of Azurius by all the reasons explained. There are 5 conditions to fit the state of necessity. The first is that must have been occasionated by the essential interest of the state author of the fact. In the present case, there is an essential interest impacted by the of the state of author of the act that was securing the right to food for the population. So the first condition is established. The second condition is that the interest must have been threatened by a great and imminent peril. So considering that there is no international trade caused by the pandemic and the reallocation of fish stocks and the scenario of forcing subsistence farming and fishing to its inhabitants, Azurius was also in a situation of grave and imminent peril. The third, the act being challenged must have been the only means of safeguarding that interest. Well, in this case, as already stated, the paralysis of the international trade stopped all the importing of food. So Azurius, as a small island developing states, already facing a severe economic crisis, could not import food. And the reallocation of fish stocks in its EEZ made it impossible for the subsistence fishers to fish along the authorized area of the EEZ of Azurius, forcing them to go high seas and following the fish stocks until the entering of the EEZ of Calypso. So in this sense, there was the only means to secure the right to food of the population, fitting the state of necessity hypothesis. The fourth condition was that act must not have seriously impaired an essential interest of the state towards the obligation existed. And in this sense, the applicant brought up that the devil race preservation was of essential interest of Calypso. Well, as stated by the applicant in its writing statement, the devil rays are an endangered species, but are not in face of risk of extinction. So in this case, the fishermen only fished 12 devil rays. Was not even on a kilogram, was only 12 devil rays. So the quantity of fish caught was insignificant, as was already stated in my first oral speak. So already the fourth condition of not impairing the essential interests of the other state is also complied. And for last, the state must not have contributed to the occurrence of the state of necessity. And in this sense, as already stated in my first oral speech, Azores did not have any control over the economic crisis caused by the pandemic or over the climate change. In this sense, it is important to highlight that the small islands developing states are recognized by international law as especially impaired with social, economic, and environmental vulnerabilities. And Azores, the government of Azores since 1998 is trying to mitigate the effects of climate change in the region. In this sense, Azores have applied a precautionary approach, implementing environmental conservation measures since 1998. In 2016, Azores established 2 large marine protected areas in its EEZ. These MPAs aims to ensure that the restoration of marine biodiversity and supporting the long-term transition of the island Azores from mass tourism to ecotourism. The Principle 15 of the Rio Declaration on Environment and Development, adopted by the 1992 United Nations Conference on environment, and the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. This principle was reproduced on Article 7.5.1 of the FAO Code of Conduct for Responsible Fisheries, implemented by Azores and Calypso within their domestic legislation, and on Article 6 of the UN Fish Stocks Agreement, ratified by both parties also. In this instrument, the Article 70.5.2 of the FAO Code of Conduct for Responsible Fisheries and Article 6.3c of the UN Fish Stocks Agreement states that in implementing the precautionary approach, states should take into account the impact of fishing activities on non-target and associated or dependent species, as well as environmental and socio-economic conditions. As we can see, Azores did not postpone any measures to prevent environmental degradation, establishing the large marine protected areas within its EEZ, precisely to prevent environmental degradation. Also about the capabilities, it is important to remember that Azores is a small island developing state, already facing specific vulnerabilities. The extent of the Azorean territory is of approximately 18% of the territory of Calypso. In this sense, Azores inhabitants rely mostly on agriculture and forestry, including fisheries, and 60% of food import and fishery sector is also much less developed than in Calypso. So in this sense, Calypso, over the principle of common but differentiated responsibility that must be considered in this case, must recognize its responsibility as a state that, even as a small island developing state, is already more developed than Azores. So in this case, it must not rely the claim of the applicant that Azores did not comply with its due diligence, and the precedents of the state of necessity were brought to this tribunal and complied by Azores, fitting the state of necessity hypothesis. And in this sense, I would like to quote the Shian Saran, Special Envoy of the Prime Minister of India for Climate Change. The architecture that we built to tackle climate change must be equitable. And in this sense, I find my rebuttal. Thank you.
Fantastic. Thank you very much. So the tribunal will now enter into deliberation. If you could please leave the room, and then we will call you back in once we've made our decision. Thank you very much, everybody. Congratulations.